Welcome, everyone, to our workshop, The 5 Most Important Decisions You Should Make to Protect Your Family Now and Forever. We thank you for attending. This workshop is being recorded, and all participants will receive a link to the recording within the next few days. My name is Patricia Clay, and I am the Director of Operations and Client Services here at Terabella Law Group. With the overload of people on the internet, sometimes screens can freeze up or microphones give you issues. So we appreciate your patience if this should happen. If you have any questions during this workshop, please enter them in the question box and we'll try to get to them. If we don't get your question answered during this workshop, we'll respond to it by email within 24 hours. Finally, John will be offering a special gift to you, so please stay until the end to hear about this gift. Again, thank you for attending, and without any more delays, I'd like to welcome John Hilton.
And thank you, Patricia. Hello, everyone. I am so glad you're here. Today, we are all about the 5 most important decisions you should make to protect your family now and forever. This is a serious topic, but these are seriously the most important decisions you can make if you want to ensure your family is protected from court and conflict when you become incapacitated or die. My name is John Hilton. I'm a dad, I'm a husband, a son, and an estate planning and elder law attorney. And thank you so much for being here today. I'm so excited about this topic, and my hope for you today is that each of you comes away from this workshop with a peace of mind that comes with knowing that you can protect your family from court and conflict at your incapacity or death, that your financial assets will never be subject to the court's discretion if you are no longer able to manage them, that your minor children will never have to be cared for by strangers for even 1 minute. And I invite you to stay with me to the end of this workshop because I want you to know that your time is well spent. And I will be presenting a special offer, like Patricia said, just for those of you who watch this entire presentation. Now, we're going to jump right in. And if you haven't already, please download your workbook so you can take notes today. The link is in any of your reminder emails leading up to today, and you'll also see it in your sidebar. Print out your workbook and make notes as we go. Now, before we get any deeper into this discussion, I would like to share with you some of the experiences our clients have had working with us. Sharon said, it was an amazing experience. I wish I had done this sooner. Keep giving your amazing service. And this person chose to give us an anonymous review, but what they said was, making an appointment was fast and gave us information on what to expect at our first meeting. The staff and support group is beyond excellent. During our several meetings, everything was explained in detail, and if we didn't understand, questions were always answered to our satisfaction. And during the shelter in place, our welfare was utmost on their minds. Now, the best way to get the most out of our time together today is to turn off your phone, close your door, and close any of the background applications going on your computer. This will be worth your time more if you turn off all those distractions, and you really do deserve this time for yourself and ultimately for your family. Now, before we move on, I have a short story to tell you. Years ago, I was training to be a paramedic in South Texas, and we took a trip over into Mexico to visit one of the hospitals there and to do some training, some cross training with the staff. And while we were outside taking a break, we saw this Red Cross ambulance, very similar to the one in this picture. And it pulled up into the bay at the hospital. And I saw the driver and the passenger both get out, and they're both wearing their white shirts with the Red Cross on the sleeve, and they walk over to the wall. They lean against the wall and they light up a couple of cigarettes, and they're just standing there talking. And I thought, well, okay, these guys are, they come in, they're taking a break. And a few minutes later, I see the back side door open, and I see a hand reach out, and then another hand. And then I see this IV pole come out, and this near-term pregnant woman laboriously climbs out of the back of this van and begins to slowly make her way up the ramp into the emergency room at this hospital, pushing her own IV pole. In the meantime, both of these Red Cross ambulance drivers were leaning against the wall watching her and talking and laughing, and made no effort whatsoever to help her get into the emergency room and get into the care of the staff in the hospital. And, you know, I have a reason for telling this story. And when you look at the picture on your screen today, what you see is a modern Mexican Red Cross training in advanced pre-hospital care techniques. And they've made huge strides in the kind of care that they provide in Mexico today, based on back in the 1980s when I observed this event. And I guess what it boils down to is the why. Now, in the 1980s, that Red Cross crew's purpose was simply to get the patient quickly to the hospital. And that was it. They got her to the hospital. The rest was up to her. But today, because of training and advances in technology, the Red Cross in Mexico understands that they need to provide care for the patient from the moment they first make contact until they actually hand off the patient to the emergency room medical staff. They've grown, they've evolved, and they've learned. But many estate planning attorneys are just like those Red Cross drivers from the 1980s. Their why is all messed up. They believe that they've done a good job if they give you a set of documents, like a will or a trust, but they don't understand that a true estate plan is so much more than documents. It's so much more than parking and letting you get out of the ambulance by yourself. There's more to be done. And a great estate planning attorney will customize your plan to you and your family's specific needs. A great estate planning attorney understands that your plan is not a once and done set of documents, but it must grow and evolve with changes in your family circumstances and changes in the law. And a great estate planning attorney will know how to ensure that your children never have to spend even 1 minute in the care and home of a stranger if the worst should happen to you. Now, let me introduce you to my family and my reason for doing what I do, my reality, my why. You'll see here my wife, my single son. I got another son who's married and has children, another son who's engaged to be married in December. Actually, two of my sons are married and have children. And what you'll see as we go through this workshop is that every one of my family members may be affected if I do nothing to protect their future. Now, this would be a great time to make sure you've got your workbook in front of you and to begin filling out page 1 in the section titled My Reality. So fill out my reality about yourself. And I'd just like to put this question out there to you. Do you currently have an estate plan in place? Now, this includes any estate planning documents whatsoever. And if not, how will the people you love be affected if you become incapacitated or when you ultimately die? And if you don't have an estate plan, and by the way, most everyone doesn't. And if you don't have an estate plan, you're right in line with the statistics that show that 62% of adults don't have any estate planning documents in place whatsoever. And if you're talking about only adults with minor children, the percentage of those adults without an estate plan is even higher. So ask yourself this question: why would you say you do not have an estate plan in place? Some of the common responses I get include things like, well, I've never gotten around to it. I know I should. I never even thought about it until I became a parent and started thinking about my kids. I never thought about it until my mom passed away and I saw what she went through. I'm not sure why I haven't done it yet, but yeah, I know I need one. Now, these are all very valid reasons, and we're going to talk about them. Now, if you do have an estate plan, what do you hope to learn today? Now, see, these are some of the common responses I get when I ask this question. Well, I think there must be gaps in my plan, but I don't know how to find them. I don't know where they are. Or, well, I did my plan a really long time ago, and I just haven't kept it up to date. Or I did my will on rocketlawyer.com, and I know it's not enough. So before we go any further, I have another question for you. Why did you decide to attend this workshop today? Maybe for any of the reasons we just discussed, or maybe COVID-19 has made you realize that you can't truly predict when your time will be up. Or maybe you realize that if you're hospitalized, you have not elected anyone to make healthcare decisions for you. Maybe you've heard about the new tax law, the Secures Act, and you wonder if it applies to you. Or maybe you're curious about how to protect your assets after they've been transferred to your beneficiaries. Or maybe you just wonder what important decisions you need to make and possibly haven't thought of yet. Now, I want you to know that you're in the right place if you have someone or something you care about and you want to protect. It doesn't matter if that something is big or small, expensive or not. In just a moment, we're going to cover the 5 most important decisions you should make to protect your family now and forever. And we're going to discover how to protect those assets and those people. Now, maybe you're not positive that a document created online will fully protect you and your family. Maybe you're wondering whether a document created online can protect you and your family, and what the supposed danger of do-it-yourself estate planning is. And if you've ever thought about that, you're in the right place. And here's a big question people are nervous about, and that is, how much will it cost? And where do I start? And how long does the process take? This seems like such a big undertaking. And I totally hear you on that. And we're going to actually go over that today. Honestly, at the end of the day, when we talk about estate planning, the reality is that estate planning is not about you. It's about the people you love most. Your loved ones will know how well your plan is working or not when the time comes. Sadly, we hear from some of our clients when a loved one passes away, they'll say, but my mom or my dad told me I took care of it. And I don't understand now why we're having to go to court, or why we have to go through these extra steps and why we have to publish anything in the newspaper. They said they'd taken care of everything. And so this is part of what we help families do. Truly take care of it, leaving no stone unturned and making sure loved ones aren't confused or caught off guard later. So let's start with the first most important decision you should make to protect your family. So the first most important decision you should make is to get organized, get financially organized. Would your family know where to find all of your banking accounts? Would they know where to find your IRAs, your life insurance policies, your investment accounts, your business records? And what happens to those assets if your family doesn't find them? There are currently approximately $1.5 billion in the Arizona State Department of Unclaimed Property. And most of that got there because someone died and their family overlooked an insurance policy, a bank account, investment, or retirement account. And this could easily happen to you if you do not get financially organized and make sure your family knows what you have in the event of your death or incapacity. Now, getting financially organized allows your family to locate your assets easily and ensure nothing is lost to the State Department of Unclaimed Property. Now, I recommend 3 simple steps to start getting your financial affairs organized and easily accessible by your family when the time comes. The first step is just to organize your estate and or business records. Get them all together. Know exactly what you have. Make sure you have all of your records in one place. And then create a spreadsheet listing all of your assets. And then to complete the process, look at all of your life insurance and retirement plans and make sure the beneficiaries that you have named are correct. We see this way too frequently, where people have named beneficiaries years ago and haven't thought about it since. And when they look at their insurance policies and their retirement plans and they see who they've named, they're like, oh no, that's not what I want. So we need to make sure that all of that is up to date and correct. So right now, look in your workbook and complete this section. I think it's section 1, and it's called Keeping My Assets Out of the State's Department of Unclaimed Property. Now, if you think it may be overwhelming to organize your assets, just imagine how much more difficult it's going to be for your loved ones when you're no longer there to even guide them. This is actually the first step we take with every client. And we help our clients through every step of this process. And at the end of this workshop, I'm going to tell you how you can get financially organized as part of your life and legacy planning session, risk-free and at no cost to you. All right, the second most important decision you should make. After getting financially organized, you want to make sure that your minor children are protected. And I hear many people say that they've already taken care of naming guardians for their minor kids. And they show me in their will that they've nominated guardians for their minor children. But this may not be enough. So as I go through the next couple of graphics, follow along with me and complete section 2 of your workbook. Now let's consider a hypothetical situation. You are fatally injured in a car accident and you leave behind 2 small children. You have a brother who's very successful. He has a stay-at-home wife, 3 children. All 3 children are excelling in school and sports. Now, you also have a sister, and she has a good job. She's not married, and she has no children. And both your brother and your sister petitioned the court for guardianship of your children. Based on this information, who do you think a court would decide is the best candidate to raise your children? The married, successful brother with children of his own, or the single sister? Now, yeah, most of you are probably thinking, well, probably the brother. But the reality is, we just really don't know. So let's add in the fact that your brother's stay-at-home wife is actually a closet alcoholic and abuses prescription drugs. And it turns out the only reason his kids are at all successful is because he makes sure they are protected from their mother's addictions. Does that change your answer? But how would the court ever know? So now let's assume you are not fatally injured in the car accident, but instead you are in a coma. And your will indicates that you prefer your sister to raise your children. But because you're not dead, you're just in a coma, your will is not even a consideration. So now, who will care for your children while you're incapacitated in a coma? So if you do have minor kids at home, I want to tell you 2 quick stories that could illustrate where your kids are at risk. And even if you've already named guardians in a will. And if you have not named guardians at all, as 69% of parents haven't, and something happens to you, the choice between who raises your kids will be left to a judge to decide. Now, several years ago, the Barber family, it was 2 parents and 3 sons, came to Arizona for a vacation, and they were traveling from California. And while traveling through Arizona, they were in a car accident and both parents died. All 3 boys lived, and when the authorities finally found a family member to pick them up, they found one of the sisters of the mom. That sister decided that she should get custody of the kids and their money, but she also prevented them from seeing any of the other family members. And after more than $100,000 in court costs and nearly a year of litigation, a huge family fight, a judge decided that a different sister should raise the boys and appointed a financial conservator over the boys' inheritance to the tune of $100 an hour. And then when the boys turn 18, at their birthday, they will receive whatever's left over. Now, even if you do have a will naming guardians, your kids could still be at risk. My colleague and mentor realized this when she was out to dinner with her husband, and her baby daughter was home with their 16-year-old babysitter. And she realized that she had named guardians, but they all lived across the country, and no one would be able to even find her will anyway. And at that point, she realized that the authorities would have no choice but to take her daughter out of her home and place her into the care of strangers until they could find her will, locate her named guardians, and then they could make their way across the country to her daughter. This was not acceptable to her, and so she created something she called a kids protection plan. And that the kids protection plan ensures that no kids are at risk ever from that happening by filling in the gaps left by a will only plan. And when you schedule your life and legacy planning session with me, we'll discuss the kids protection plan in greater detail. And I'm going to actually give you an opportunity to do that at the end of this workshop at no cost and no risk whatsoever to you. Now, here's another reason you might want to consider a kids protection plan. If there is anyone in your life you would never want raising your kids, a will does not exclude anyone from guardianship. It only nominates your preference. And if you know you would never want a specific person raising your kids or challenging your choices, a kids protection plan will keep those people from ever raising your children. Now, here's the bottom line. If you do not have proper and complete legal planning in place to protect your children, a court will decide who will care for your children in the short term while it sorts out who will raise them in the long term. And if you don't have a way to let the court know who you believe should never be allowed to raise your children, the court has no way of knowing, and that person could end up caring for and raising your child. Okay, so you should have completed section 2 of your workbook now. So we're going to move forward to the third most important decision you should make to protect your family. All right, so the third most important decision you should make is to plan for your financial incapacity. Now, while I tell you the following story, I'd like for you to start completing section 3 of your workbook. So Bill was an 84-year-old multimillionaire. Bill made his fortune trading on the stock market. And one day he met this 25-year-old video store clerk and started teaching him how to make money trading stocks. After a few months, Bill gave the video store clerk $14,000 and challenged him to invest it and turn it into much more money. Well, Bill's daughters learned about the $14,000 and immediately decided Bill had lost all judgment and capacity to make decisions about his money. They petitioned the court for emergency guardianship and conservatorship. Now, in Arizona, guardianship refers to control over the person, and conservatorship refers to control over financial affairs. After months of hearings, The court granted their petition and appointed one of Bill's daughters as his guardian and conservator. As a result, Bill lost all of his rights to drive, his right to vote, his right to determine where he would live and who his friends could be. He also lost all of his right to control any of his money. During the final hearing, after the judge had made his final determination, Bill pleaded with the judge to appoint anyone other than his daughter. He explained to the judge that his daughter was a mean and ugly person, and his daughter had been trying to get control of his money for years. But the judge would not be dissuaded. Bill ultimately appealed to the Arizona Court of Appeals and ultimately then to the Arizona Supreme Court, and still could not get that ruling changed. And Bill's life, as he had once known it, was over. What could Bill have done differently? Well, Bill could have created a power of attorney in which he named his personal choice for who would control his assets when he was no longer able. And even if the court decided he needed a guardian, the guardian would not have gained access to his fortune. Even better, Bill could have transferred all of his assets to a trust and named a successor trustee to manage his financial affairs for him when he became incapacitated. So hopefully at this point, you've completed section 3 of your workbook, and it should be pretty easy. Just select the one statement that best describes your current reality. Now, let's move to important decision number 4. We just talked about planning for your financial incapacity. Let's talk about your physical incapacity. While I tell the following story, start completing section 4 of your workbook. So this is Terry Schiavo, and many of you probably remember the story of Terry Schiavo. It was back in the 80s. To the best of our knowledge today, Terry suffered brain damage after suffering a cardiac event due to an eating disorder. And because of the brain damage and her vegetative state, her husband wanted to remove her from life support. Her parents were adamantly opposed and wanted her to remain on life support and be kept alive indefinitely. And the husband and the parents fought over Terry Schiavo's life for about 5 years. Ended up going to the Supreme Court, United States Supreme Court, on 3 different issues to determine who had the rights over Terry's life. And eventually, after 5 years, the husband's right won out and Terry was removed from life support. Now, these terrible events could have been avoided if Terry had properly executed one simple document. Now, many of you have executed such a document, but I can guarantee that for many of you, it's out of date and won't work when you need it. And it's unlikely to be comprehensive enough and provide enough detailed guidance on how you want to be cared for in the event you become incapacitated. And as you all know, that document we're talking about is a living will and a healthcare power of attorney. Now, if you want to make sure that your wishes are comprehensive and honored at your incapacity, if you have specific wishes for how you would want medical decisions made for you, I want you to keep listening and take advantage of the special offer to meet with me that we'll present at the end of this workshop. But right now, make sure that you are completing section 4 of your workbook, and so specifically the part on planning for the possibility of your terminal illness, your coma or vegetative state. And I got another more current story. Recently, just a few months ago, this young couple got engaged and were planning their wedding with great anticipation, thinking about their future life together. Then the groom became ill and was hospitalized with COVID-19. Within a day of his diagnosis, he was in the ICU on a ventilator. His fiancée tried desperately to get the hospital staff to tell her what was going on. But because she was not a blood relative, they refused to tell her anything. And obviously, he was not able to give permission for the healthcare staff to speak with her because he was in a coma. He was intubated. And because it was COVID-19, she was not allowed to even enter the hospital or try to visit him. A couple of days after this woman's fiance was admitted to the hospital, someone in the ICU finally told her that her fiance had been moved to a different floor, and she was thrilled. She believed that he must have gotten better and didn't need ICU care any longer. But after calling around all day, she finally found him, only he hadn't gotten any better. He had been moved to the morgue. He had died. So what could this couple have done differently to avoid this heartbreaking end to their happy romance and engagement? What one decision could they have made that would have allowed her to speak with the hospital staff and keep abreast of his progress? Like I said before, they could have created a healthcare power of attorney and a living will. One additional point related to planning for possible future incapacity. Will you or your aging parent at some point need long-term care? The average cost of long-term care in Arizona is $90,000 a year. And if you have, let's say, $100,000 in life savings, you will not qualify for Arizona long-term care system or all tax assistance, Medicaid. Within 1 year of being admitted to long-term care, to skilled nursing care, you will have exhausted your entire life savings just paying for your long-term care. Now, the good news is that we can help you plan to keep your hard-earned money while still qualifying for state assistance to pay for long-term care. So more about that later. Let's move on to the final, most important decision that you should make to ensure your family is protected. What happens when you eventually die? So the fifth most important decision you should make is to plan for your death. And this is, probably the most important decision you should make, because you want to remain in control of what happens when you die. And you don't want to leave it up to a court to decide. And you don't want to put your family in the middle of conflict. So let's start off talking about your estate plan. There are 3 possible scenarios for everybody. One is you have a will. The other option is you have a trust. And the third option is you have not done any planning yet. Those are the only 3 categories you can fit in. You have a will, you have a trust, or you have done no planning at all. Now, this does not mean that you don't have a plan, because the state of Arizona actually has a plan for you if you do not plan for yourself. You may not like it. Now, while I continue talking, go to Section 5 in your workbook, the first part of Section 5 called My Current Estate Plan, and start completing that. Now, assuming you've created a trust or a will, when was the last time you had it reviewed? Because of changes in your circumstances and changes in the law, your estate plan should be reviewed at least every 3 years. Additionally, you should make sure your plan was created with a lawyer who made sure your plan will work when your family needs it the most. So let's review the state's estate plan for you if you have not done any planning, if you don't have an estate plan, a will, or a trust in place. Because if you have no estate plan and then become incapacitated or die, the state does have a plan for you. Now, if you become incapacitated, this plan involves a court process called guardianship or conservatorship. It's called going to court, so a judge can appoint someone to make decisions for you and or give a guardian or conservator access to your assets or direct where your assets should go, just like the story of Bill. If you've died It involves a court process called probate. And this means your family has to go to court and the judge decides where your money goes. And it may not be to whom you would choose or in the amounts you would choose. And even if you do have a will, your family will still go through this same probate process. The only difference is that with a will, you get to decide who will receive your assets when you die. Now, here's the deal. Going to court is expensive. There are attorney's fees and executor's fees and appraiser's fees, court filing fees, bond premiums, and creditor's claims. And in Arizona, even a simple probate today takes a minimum of 9 to 12 months. During this time, your creditors are getting paid, but your loved ones may not have access to your assets. Now, who would you rather have your assets available to them immediately after you die? Your creditors or your children? Additionally, for your family, probate takes an enormous amount of energy and attention. I have yet to speak with a client who's gone through the probate process who would ever choose for their family to have the same experience when they die. So now would be a really good time to begin completing the section in your workbook called Probate on page 4. Now here's the other thing. Probate is also totally public, meaning anyone can go down to the courthouse and pull your court records to see what you own and who is getting it. On your screen, you will see the will of Jackie Onassis. Now, would you like to see the will of, I don't know, John Lennon, JFK Jr., Babe Ruth, Jerry Garcia? You could, because they all went through the court process and they're all public records. Okay, so here's my point. A will is public and does not avoid probate. When a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money. The only plan that is private, avoids probate, and ensures your children receive your assets when you want and how you want, and can save you substantial estate taxes, is a properly funded trust. But we're going to talk more about that later. Also, and maybe worst of all, with a will going through probate, your children would be entitled to all of your assets outright without any restriction at age 18. And I'm sure you can imagine what your 18-year-old child would do if they suddenly inherited your life insurance policy. And finally, you may want to ensure that your kids receive their inheritance protected from lawsuits against them, protected from future creditors, and even a future divorce. Most adult children have no idea how to keep an inheritance separate from their community property. And as a result, will typically lose half of it to a future ex-spouse during a divorce. However, if you leave their inheritance in a protected trust, your children will be able to keep all of it, even if they get divorced, file bankruptcy, or have a court judgment against them. Now, go back to your workbook and ensure you've completed parts 2 and 3 of section 5, probate and the estates plan. While you're completing your workbook, let's talk about Aretha Franklin. Now, Aretha Franklin died a couple of years ago, leaving behind 3 adult children, one of whom has special needs. Now, her family eventually found 3 different wills, each will leaving her multi-million-dollar estate to her children in different amounts. In one of her wills, she even disinherited her son with special needs. Now, Aretha's family is going to be spending much of her estate fighting over which will the court should admit to probate. And speaking of Aretha Franklin's son with special needs, how could she have done things differently? Well, first of all, she could have established a revocable living trust and avoided having her children fight about which will to probate. Then she could have set up a special needs trust for her son, which would have protected his inheritance from outside influence, creditors, lawsuits, anything like that, while at the same time ensuring he could always get access to public benefits if he needed them. Now, I discussed these options in greater detail in my other workshop called The 5 Critical Steps You Must Take to Plan for the Future Care of Your Child with Special Needs the Right Way. For now, if you have a child with special needs, complete the section of your workbook on page 6 called My Loved Ones with Special Needs. And if you want to know more about our special needs workshop, please contact us. The email address will be posted at the end of this workshop. So getting back to probate, many people think that they can avoid all of this probate stuff by either owning property jointly or designating a beneficiary for their assets or by signing a will. Now, joint ownership has many problems. Now, if you remember when you were in escrow in your home, you probably remember that the escrow agent asked you how you wanted to take title to your home. If you're single, you probably said just in your own name. If you're married, you probably said as joint tenants. I'm going to keep talking about this, but while I do, go ahead and complete the section in your workbook on page 7 titled My Probate Avoidance Strategies. So if you said that you wanted to take property as joint tenants, you do have the benefit of avoiding probate upon the death of the first of you to die. But the downside is that you can't ensure that the surviving joint tenant won't give all the property away to a future spouse, or that the surviving joint tenant won't lose all of the assets to creditors. Additionally, you lose the benefit of erasing all of the built-in capital gain on the property upon death. Now, in a community property state like Arizona, if you took title as community property, you do get to erase all the built-in capital gain when one of you dies, but 1/2 of the property will be subject to probate. So you can see there are potential problems with both of those options. Now, designating a beneficiary is an option where assets permit, but many assets don't permit beneficiary designations. And where you designate a beneficiary, the beneficiary has unlimited control over the asset. It can be lost, it can be given away, just like community property. Worst of all, if you name a minor as a beneficiary, that just ensures that your insurance or retirement account will end up in court if you die before your kids turn 18. Now, as we already talked about, signing a will won't work, won't keep you out of probate. Now, there is a better plan, and that plan is called a revocable living trust. When you create a trust, you get to choose how to distribute your assets to your heirs. They don't just receive their assets at 18, but instead, according to a schedule you determine. Most trusts distribute assets to their beneficiaries at certain ages or stages. For example, a trust may say that the beneficiary can receive their inheritance 1/3 at age 25, 1/2 at age 30, and the remaining balance at age 35. Or it may say that they can get 1/2 upon graduation from college and the balance upon graduation from graduate school. This is an acceptable way to plan, but there is an even better way. How many of you would like to own assets that can never be touched by creditors, will never be subject to estate taxes, and can never be taken away in the event of a divorce? Yeah, of course, we'd all like that. But now, what if I said that I could give you all of this, but you could not control those assets? You'd probably be a little less interested. Well, in our living trust, you can give your children assets that can never be touched by creditors, will never be subject to estate tax, and can never be taken away in the event of a divorce. And you can give them complete control. Now, these are cutting-edge techniques that only the most knowledgeable estate planning attorneys are taking advantage of. And I'm betting most of you would want to include that in your plan. So while I move on to the next graphic, complete the section on page 7 of your workbook titled Protection of My Assets from Divorce, Creditors, and Lawsuits. So like I said, the only way to keep your family out of court, either in the event of your death or incapacity, is to have a fully funded living trust. This means that you've got a trust prepared that is properly custom drafted for your family to say exactly what you want to happen to your assets in the event of your incapacity or death. And all of your assets are owned in the name of your trust. Now, if you already have a trust, chances are it's not been updated since you created it. And it's likely out of date because your life has changed, the law has changed, or your assets have changed. And it's also very likely that your assets are not even properly owned in the name of the trust. You know, we get this all the time. A client will come in and say, hey, would you review my trust for me? I just want to make sure it's up to date. The very first question I ask them before I even look at their trust is, what assets are titled in the name of your trust? And more often than not, the client will look at me with a glazed look in their eye and basically say, I don't know what you're talking about. And I'll ask them, when you get your tax statement on your home, does it come to you as the trustee of your trust, or does it just come to you? When you get your bank statements, do they come just to you or to you as the trustee of your trust? And they'll often just look at me and say, they just all come to me. And so right away, I tell them, it doesn't matter what your trust says. Your trust is not going to work for you. When your family needs it, your trust isn't going to work. One of the most common problems when people create a trust is failure to properly fund it or to failure to properly transfer their assets to the trust. And this is all too common with people who go online and create their trust, or who use that cheap lawyer down the street who knows how to use a drafting program and create a trust, but doesn't know how to properly guide the client to make sure that they complete the process and transfer all their assets. You know, that guy's just like the Red Cross ambulance driver who goes and stands against the wall and smokes a cigarette while he watches the patient climb, into the emergency room. They've gotten you the documents, they've gotten you to the ER, but they haven't taken you all the way. And it will not work for you when your family needs it. And the other thing is, if you do this online, or if you use that cheap lawyer who does estate planning and DUIs and divorces and whatever else you need, they are not equipped to properly guide you to make the informed and empowered decisions that you need to make, and then to help keep your plan updated and to keep your assets properly owned. So if you do have a trust, go ahead and complete the section titled My Trust on page 8 of your workbook. And we're nearing the end of this workshop, and I want to reassure you that I will soon be telling you how you can get on my schedule at no cost to you and at absolutely no risk, so we can discuss your family's situation, your assets, and how you would like to pass your assets on to your loved ones. Now, what about estate taxes? And this one applied to many of you, but just in case any of you do have assets in excess of $11.4 million, or maybe you're expecting an inheritance that could put you in that category, you need to know that your family could lose nearly half of all your assets to the government in excess of $11.4 million, even if you receive it by inheritance. Now, I'm not going to spend a lot of time on that right now because it doesn't apply to most of us, but if that is you, go ahead and complete the section in your workbook called My Estate Taxes on page 8. All right, so we went through the 5 steps, but I actually have a bonus step for you, and that is to plan for your legacy. Now, this is the last thing I'm going to ask you. If you had to choose between the people you love receiving your money or receiving your values, insights, stories, and life experience, what would you choose? Now, most people say if they had to choose, they would choose their non-monetary assets, their intellectual, spiritual, and human capital. So it makes no sense that most estate plans completely ignore this altogether. Um, you know, I have memories of my dad, who was he was a pastor of a church, but he was a great, just storyteller, and he, those are the memories that I have. And my dad, he died without any assets. And before he died, he told me, Johnny, I just have one regret. I wish I could have left each of my kids $5,000. And I remember, telling my dad, Dad, you've left us a gift so much greater than $5,000. You've left me personally with skills. I used to help my dad build, and I know how to build things now. And I know how to roof and paint and plumb and do electricity. I know how to teach, and I know how to study, and I know how to be a giving person, and I know how to be generous because of my dad. And I told him that that's the gift you've left me. That's my inheritance. And I didn't understand at the time to tell him, you've left me a legacy. And, then that was so much more important to me than any money he could have scraped together and left me when he died. So one of the most valuable gifts that you can leave your family is that of your values, your stories, your insights, the wisdom that you've earned by your life experiences. Collectively, this gift is your legacy. Now, as I quickly go through the next few graphics, on page 9 of your workbook, start jotting down some notes to help you remember the values, stories, and wisdom that you would want to pass on to your family. Now, many people mistakenly believe that their legacy is only about how much money they leave behind. The truth is, your legacy is about your loved ones having your insights, your values, your stories, and your experiences as a way to remember you. Now, as an attorney, I don't feel like I'm serving you well if I just draft the legal documents and I don't even touch on the fact that your legacy is more important than what you just did with legal documents. And actually, I see that as one of my actually primary purposes in life as an attorney, as a parent, a son, and a husband. This is the reason I'm here, is to help client families get an estate plan in place and help them begin to capture their legacy while they do it. But the most important thing is that you actually sit down and do it. And I have just a couple of questions around legacy. You have a legacy today. You may not like what your legacy looks like today. It may not be the legacy you want to leave your family. But you can start right now creating the legacy you do want your family, friends, and community to remember you by. And you can start by asking yourself these 2 simple questions. What do you value most about your life up to this point? Capitalize on that. And then the second question, looking forward. If time or money were not an issue, what would your future look like? What would it look like for you? What would it look like for your family after you're gone? Claim that. Go after that. Make that what the rest of your life is about. Leave the family, leave your community, your friends, the legacy you want them to have to remember you by. There are several ways that you can begin to do that. And we call this FISHES, F-I-S-H-S, and it stands for financial, intellectual, social, human, and spiritual. And what this talks about is anytime you create anything of value, you have to invest in it. You have to invest capital. And here we're talking about the financial, intellectual, social, human, and spiritual capital that you can invest in to begin to create your legacy. You know, from a financial standpoint, we're looking at things like, you know, your business, your family foundation, even your estate plan. These are all financial capital that you invest in as part of your legacy. On the intellectual side, we're looking at what knowledge and skills have you learned or will you pass on to your children? What are you currently investing in as intellectual capital? Are you learning new skills? And going on. On the social side, what kind of social investments are you making? And maybe you're at a point in your life where you're not making social investments in yourself anymore, but maybe it's time to make social investments into your children by exposing them to your connections and your network so that as they grow into adults, they'll have the opportunity to capitalize on those connections in your network and become successful as adults. When you think about your legacy from the human standpoint, what are the stories and the wisdom, the life experiences that your family and community will remember you by? And finally, spiritually, you know, what spiritual guidance do you provide your family? Now, we're not talking here just about religion. We're talking about a much higher level of spirituality. But speaking of religion, one of the most common legacy planning concerns I encounter with families is how to pass down to their children and grandchildren their religious values. But more importantly, how to ensure their own spiritual or religious values are honored when they become incapacitated or die. And this is an important part of your estate plan and something that will not be included in your estate plan if you choose a do-it-yourself online plan or use that cheap lawyer down the street to simply draft documents for you. So, okay, here we are. We've gone over 5 steps, and what I believe are the 5 most important steps you can take to plan for and protect your family and your loved ones. The first one is to get financially organized. Protect your children. Don't ever let them be taken into the home of strangers. Plan for your financial incapacity by making sure you have a comprehensive power of attorney and other financial planning documents. Plan for your physical incapacity by making sure you've got your healthcare power of attorney and your living will in place. And then ultimately plan for your death so your family does not have to go through the probate process if it's not necessary. And so that your family can receive your assets at an age and in a way and in a manner that you prefer without going through probate. And if you wish, that they can receive those assets in a protected trust that will protect them from future divorce and creditors and lawsuits and taxes. And as a part of that, plan for your legacy. And you can start that today by looking, at exactly what it is that you want to be remembered for, and then creating it every day, starting today, by investing in your financial, intellectual, social, human, and spiritual assets. Okay, so now what? Well, I hope that I've provided you with some helpful information and some hope for the future of your family. I really don't want to leave you hanging with unanswered questions or wondering just what you're supposed to do next. Now that you know there are options that will allow you to protect your minor children from ever being taken in by strangers, There are options to ensure your financial affairs will always be taken care of if you become incapacitated. To know that your healthcare wishes will be carried out in the event of your physical incapacity. And that there are options that will keep your family from having to go through the adversarial court process called probate when you die. Now, I would love to meet with you with no obligations to discuss your options. Now, if you're like me, you're probably wondering why you should even consider working with someone you've never met or haven't even heard of before this workshop. And I wouldn't blame you if you had reservations, but I would ask that you give me a chance at no risk to you to just sit down with you and discuss your concerns, because I'm not your typical attorney, and I would love to have the opportunity to prove it to you. Now, the reality is that our legal system is much like that Red Cross crew I told you about at the beginning of this workshop. Most estate planning attorneys will get you to the door, but after that, you're on your own to finish doing the work of making sure your estate plan will actually work for your family when they need it most, and to keep your family out of court and out of conflict when you eventually become incapacitated or die. When I conducted an online search for attorney photos, this is what turned up, what you see on your screen. And this, if this is what you are hoping to find in your relationship with an attorney, you probably do not want to work with me. I can candidly say I am not that kind of attorney. First of all, I value my relationships with my clients above all else. And I work hard to develop and maintain those relationships year after year. Also, I so strongly believe in what I do. I've built a team of qualified people to work with me to make your plan a reality, to be there when you need us, to provide advice and direction, to answer questions, and ultimately to ensure your plan works when you need it most. And finally, I believe you should get value for what you invest in. And make no mistake, this is one of the most valuable investments you will make in your lifetime. This planning provides you with the peace of mind of knowing that you've demonstrated a true act of love for your family. Because of your plan, your children will never face the horror of losing a parent and then being forced into the care and home of a stranger. Because you love your family, they will know exactly what healthcare decisions you want carried out when you can no longer communicate them yourself. And they will come to really appreciate how much you love them when they discover that they will not have to go through the probate court process when you eventually die. So, unlike many attorneys, I only charge a flat fee for this investment, and there are never any hidden costs or surprises. Now, to demonstrate to you my commitment to my clients, I'd like to just share what a few of them have to say. Vicky Sue said, John is not your typical attorney. He makes sure you understand all legal documents in plain and simple terms. He takes the time to get to know you and is always there to help. It has been a privilege to be his client. Norman and Donna said, we found John and Patricia both to be very personable, easy to understand, and helpful. We feel as if we've known you both for a long time, almost like family. And that, to me, that I just love that, because like I said before, what I value above all else is my relationship with my clients. And then Bree said, this has been a wonderful experience while making difficult decisions. I am so glad I was in the hands of John K. Hilton's group. They were patient, helped me through the process, and guided me through setting up vital next steps in the event of my family needs it one day. So here is our promise to you. Your estate plan leaves no stone unturned and will give you the peace of mind your loved ones and assets are kept out of court and conflict. So how do you get started? Well, we begin all of our planning with what we call a life and legacy planning session. And this is a process that our clients absolutely love And you will too, because it supports you to become more financially organized than you have ever been before, and ensures you make informed, empowered decisions for the people you love, so you know what you actually need to have in place and what you don't. And during the process, you're going to actually choose your own fee for the planning you do. And by the end of it, you know with certainty you're making the best decisions throughout your life, and your family will know how much you cared about and loved them in the event of your incapacity or death, because everything will be so well handled. Ultimately, this is something you do for the people you love. Now, you've stayed with me throughout this entire presentation because you have questions about how to care for and protect your family. And I want you to know that you don't have to walk away with more questions and no answers. So I want to make it easy for you to get started getting the answers to your questions at no risk to you. All you have to do is schedule your free Life and Legacy Family Planning session with me to get started. I'm going to tell you how to do that in just a moment. You know, and it doesn't matter where in Arizona you live or where your other family members live. We love to meet our clients in person, but we can also meet with the entire family wherever they are via teleconference. And this type of planning can easily be completed remotely, and we can even notarize your signed documents remotely. So what I'd like for you to do now is go to the bottom of page 9 in your workbook and complete the final question, my truth. And then make a promise to yourself that no matter what, you will take the necessary steps to keep your family out of court and out of conflict at your incapacity or death. And whether you work with me or whether you work with another qualified attorney, make that promise to yourself. And then to seal this deal, to seal this promise with yourself, go ahead and sign and date your workbook. So here is the 3-meeting process that we use to get your estate plan in place. And I told you at the very beginning that we would talk about this. So the initial meeting is called a Life and Legacy Planning session. We sit down, one-on-one meeting together. Before that meeting, you complete an online Life and Legacy assessment, which is it's an easy and secure way to provide us key information about you and your family, your assets, and your values. And this is really important information that I actually review in advance of our meeting together. At your planning session, we hit the ground running. You ask questions, I ask you questions, you choose your desired estate plan, and then we start designing your plan together that day. I go over the engagement agreement. You indicate which estate plan you've chosen. We talk about the flat fee, and you sign and you make a down payment at that meeting. About 4 weeks after that, we actually get together for what we call a signing ceremony, and this is when your plan is legally in place. This is the big day. You know, bring champagne and toast this day if you want, because today is the day that you sign all of your documents and your plan is in effect. And everything that you have expressed as your wishes and everything that we've talked about and decided is reflected in your legal documents. At your signing ceremony, typically we'll have you pay the balance of your fee. And then a few weeks later, we meet for the final meeting. And this is where we really focus on the most important aspect of your plan, that your plan is an evolving thing. And as you and your family grow and change, so will your plan. So all told, this process is about an 8-week process from beginning to end to get your estate plan in place and to ensure that we've helped you transfer all of your assets to the trust so it's fully funded if you have a trust plan. But you know, ultimately, the most important aspect of your plan is what you create. What you're creating is a personalized plan for your loved ones. You're capturing your family wealth in a way where your loved ones will actually know and understand your insights, your values, your stories and experiences. And ultimately, you're creating peace of mind. And this is also what you're taking home, along with your estate plan documents. Now, as I mentioned earlier, there's a bonus for staying on to the end. So congratulations for sticking it out with me. For this life and legacy planning session that I mentioned, I typically charge $750 to meet with me. It's a 2-hour meeting, and it's filled with education and information designed to empower you to make the best decisions for your family. But the first bonus that I have for you as my guest tonight is access to my online scheduler at no charge. So you can schedule your personal family life and legacy protection session with me, and we'll meet one-on-one, get started on your estate plan. If you schedule your 2-hour meeting with me by the end of this workshop, I'll take an additional $250 off any trust plan we decide to create for you. So again, I'm offering you this free meeting valued at $750. That's what I charge for a 2-hour meeting. And if you go ahead and go to my scheduler by the end of this workshop, I'll take $250 off of any trust plan. Now, again, no cost, no risk. If you decide you want to work with me, then great. We can get started right away. If for some reason you decide to do nothing, then you will at least leave having been fully educated and informed of your options. So to get started, you can see this on the screen. All you have to do is go to terrabellalaw.com/schedule-online. That's terrabellalaw.com/schedule-online. Before we end this workshop in about 15 minutes, and schedule your 2-hour meeting with me. If you do that, the next 15 minutes or so before this workshop ends, you'll get the $750 valued 2-hour meeting with me at no cost, and you'll get the $250 off of a trust plan. So it's a $1,000 gift to you for sticking it out with me tonight, and hopefully learning something in the process. Now, when you go to terrabellalaw.com/schedule-online, it's going to take you to a scheduling page. And at the bottom of that page, there's a promo code. And what I'd like for you to place in that promo code is I attended live. So the promo code I attended live in order to get these gifts. Now remember, it does not matter where in Arizona you live or where your other family members live. I would love to meet with you in person, but if it's not possible, we can absolutely meet with you wherever you are via teleconference. And so we can do all of this remotely. Like I say, even the notarization of your documents, all can be done via teleconference. So when you schedule your 2-hour life and legacy planning session, you'll see the option for a virtual meeting. So just select the virtual meeting option if you prefer to meet with me via teleconference. Now, I take a very limited number of new clients every month. My time is very limited. So appointment slots are offered first come, first serve. So now is probably the best time to go to terrabellalaw.com/schedule-online and reserve your 2-hour meeting with me. Again, no cost to you, no risk to you. And if you do that before the end of this workshop, I'll throw in that additional $250 discount toward a trust plan. Just be sure to enter the promo code at the bottom of the scheduling form, I attended live. So what are your next steps? You can see again, it's on the screen. I'm not going to say it again. Schedule your free life and legacy planning session. Put the I attended live promo code at the bottom of the form, and then just show up, design your plan, and leave with peace of mind. It's that simple. Thank you so much for giving me the opportunity to educate you today. I hope you've walked away with more answers than questions, but we do have time for questions. And so that's what this next time is about before we end the workshop. So while we take questions, you have time, check your calendars, see what works for you. You'll look at my schedule, see what's available, check your calendar, and find a slot that works for you for your life and legacy planning session. Go ahead and get on my calendar. Again, I'm waiving the $750 fee for you, and I'm throwing in a $250 discount toward a trust plan if you schedule before we end this workshop. Now, Patricia's going to cover some of the most frequently asked questions that come up during this workshops. And then we'll see if there are any additional questions we did not cover in the question box. So if you have any question at all, go ahead and enter your question into the question box, and we'll get to it at the end if we haven't addressed it already in the most common questions that we encounter. At any time during the next 15 minutes or so, if a question comes up, please write it into the question box so we can make sure we get your question answered. If for some reason we do not get to your question, then we will definitely see it and we will respond by email to you within the next 24 hours because we want to make sure every question is answered. And if for some reason, maybe a question occurs to you after this workshop has ended, and you're like, oh, I wish I had asked John this, just email us. Write down this email address, maria@terrabellalaw.com. Send your questions to Maria, and we will make sure that we get an answer back to you right away. All right, so booking is open. Go ahead and go to the site there, the scheduling site on the screen. Put in I attended live in the promo code, and we're going to go ahead and take questions from Patricia.
Okay, John, can you hear me?
I can.
Great. So here's a very common question that I hear a lot. I don't have a very large estate. Some people have larger than they think. Do I still need a trust?
That is a common question. We get it in the workshops a lot, and we also get it during our life and legacy planning sessions. Mm-hmm. Here's the thing. If you talk to a lot of advisors, financial advisors and accountants, they'll all come up with different criteria. Well, if you have more than $500,000, you need a trust, otherwise don't worry about it. Some will say $100,000. They're all arbitrary numbers, and they don't really mean anything. The bottom line is that there are many reasons to create a trust, but one of them, and it doesn't matter whether you have $100,000 or $1 million or $20 million, is if you just want your family to not have to go through probate when you die. And a trust will absolutely avoid probate. It's private, so no one ever knows what you have and who received it or when. So it's not a public process like probate. It's immediate, and so your family doesn't have to wait 9, 12, 18, 24 months to receive their inheritance. They get it virtually immediately. So if you want to have your family avoid the painful experience of probate, then it doesn't really matter whether you have a large estate or whether you think you have enough assets. A trust will help your family, or actually will eliminate the prospect of probate for your family.
So here's another one. If we are a blended family, do you recommend one trust or two trusts?
That I'm going to give a lawyer response to that. It all depends. For many blended families, we're able to do one trust, and we have some unique design prospects that we can do in a trust to really make it work really well for a blended family, to ensure that all the children are fairly and properly cared for, despite which partner dies first. But in other situations, I actually just spoke with a client last night, and we talked about it, and we decided that they needed two separate trusts. The only way to really know what's best is to sit down in a life and legacy planning session, look at your assets, discuss what you want to happen, what your desires are when you die, and then evaluate from there and decide together which is the best way to go.
Here's one I get quite often. How long should I plan to set aside for the life and legacy planning session, and what are the payment options?
Yeah, it's a good one. So the life and legacy planning session is scheduled for 2 hours. We have some people who don't take near that much time. We have others that we actually have to schedule a follow-up session for. But plan to spend 2 hours in the life and legacy planning session. And, if we need more time, we'll schedule another meeting. It's your time to be used by you to become educated and informed and empowered to make the best decision for your family. We typically will ask for, if you decide to move forward with planning, we typically decide for 1/2 of the fee to be paid in advance. And then 4 weeks later, when we come back and sign all of your documents, we ask for the remaining of the fee to be paid. Not everybody can do that. And so I always tell the clients, work with Patricia. Patricia works magic. So, we'll find a way to ensure that you're able to make this plan for your family affordable for you and for your family.
Yeah, I want to also add that if people need finance options, we work with some people that we can hook you up with. It's a third party, but they can help you out. And so don't let money slow you up on taking care of your family. So
yeah, I mean, this planning is too important to put off because the cash flow isn't there today.
it really is. So John, here's one. If we plan on having more children, should we wait to do our estate plan to make sure that they're covered?
In short, no. And the reason I say that is your estate plan, while it would name any children that have been born at the point that we designed the plan, does not exclude any future children. In fact, it automatically includes them. And so we have provisions in, whether it's a will-based plan or a trust-based plan, we have provisions that automatically include future born children or future adopted children into the plan. So my recommendation to people is, go ahead and get that plan in place now. It will protect the children that are yet to be born or yet to be adopted. And it's really simple to go in and add children later if you want them specifically named in your estate plan.
So a recent question was, I've existing estate planning documents. So how does that fit into the estate planning options that you have available?
Yeah, so this happens, fairly frequently. A client will come in and they've already done some planning. Sometimes they've done some on their own and they decide that it's too complex and they really need professional help. Sometimes they may have started with another attorney and then they want to come in and finish up with us. So the way I approach this is I look at any estate plan documents that have already been drafted and signed and that the client brings in, and I evaluate them to ensure that they meet my quality standards. If it's a document that I would be proud to have drafted and created for that client, then I'm happy to go ahead and use it and include it. If not, then I will point out to the client the areas where I feel like the planning they've already done may not be adequate. And then we'll take from there and decide if we need to do additional planning. If we utilize those planning documents, then we can definitely adjust the cost of the planning that we do to compensate for that. It's usually not a significant reduction in cost because so many of the costs are tied up in other aspects other than just printing documents.
If I do have an estate plan in Arizona, but then I move to a different state, what happens to my plan?
Yeah, your plan goes with you. The plan is valid in all of the United States. And the only thing we would recommend is that once you are settled in your new state, that you do speak with a qualified estate planning attorney just to make a slight change to your documents to show that they are now under the jurisdiction of the new state that you've moved to, and that they comply with any trust or will statutes that state may have in place.
So this is a common one, not just about having a baby, but moving out of, I'm going on vacation or something like that. Is there a way to expedite the process?
Absolutely. Our typical process is an 8-week process. The first 4 weeks of that are taken up by designing and drafting the plan, making sure we have it exactly right before you come in and sign. But yeah, sometimes situations arise, people need something a little faster, and we are able to adjust the schedule and accommodate that.
So this is kind of our last question. What if I have a family member I would never allow to be guardian of my children? How do I protect my children?
So this is included in our kids protection plan. And what we are able to do actually is to create what we call a letter of exclusion that identifies the person or persons that you would never want to raise your children if you're no longer capable of doing so. And it tells the court why you feel that way, so that the court has really some objective, reason to look at this person differently and to honor your wish that that person never be allowed to raise or care for your child. The courts have to make a decision based on what's in the best interest of the child. So if you provide the court with a good reason why that person should not be allowed to raise your child, the court has to give it really serious consideration.
So John, I'm not seeing any questions that have been posted. So I think that's it.
All right. Well, thank you so much, Patricia. Thank you, everybody. Again, I'm going to give you one last chance, if you have not done so already, to get on my schedule and take advantage of the $1,000 in gifts that I'm offering for having stuck with me tonight. Go to terabellalaw.com/schedule online. You've got about 15 more seconds to get on there and enter the code I attended live at the bottom of that form. Now, if you don't make it, that's okay. Give Patricia a call at the office. The number is 520-428-1188. Call Patricia tomorrow and just let her know, hey, I tried to get on, I didn't make it in time. I really want to take advantage of that offer. If you are really anxious and you don't want to have to wait till tomorrow to call, go ahead and just send us an email. Send it to Maria@terabellalaw.com, and we'll make sure Patricia gets that email, and just let her know, hey, I was listening to the workshop. I tried to get on to John's schedule. I didn't make it in time. I really like to take advantage of the offer, and we'll make sure that we honor that for you. So again, thank you, everybody. Thank you, Patricia, and we will see you next time.